We're continuing our discussion of agency law and talking about the contract liability of an agent. The second part of contract liability has to do with any liability the agent may have incurred by representing a principal in a contract matter. The first question you're going to ask is, was the principal disclosed? If not, the agent is normally bound by the contract entered on the principal's behalf. For a disclosed principal, disclosed means, did the third party know that, number one, there was a principal, and two, who that principal was? If your answer to both of those questions is yes, they knew there was a principal, they knew who the principal was, then is the agent liable if the agent acted with authority on entering the contract? Is the agent personally liable? And the answer is no. Why would he be? Again, if courts protect the reasonable expectations of the parties, on whom is the third party relying when they entered the contract? Well, on the disclosed principal. Let's suppose that Daniel is buying a house and his agent is David. Daniel then authorizes David to bid up to $1 million for this fabulous place that he wants to buy in Pacific Palisades. David goes to the seller, and let's just say that the seller's name is Karen, and says, Karen, I'm David and I represent Daniel. Let's negotiate. And again, acting with written authority, David enters the contract on behalf of Daniel, signing for Daniel, and demonstrating to Karen that he has the power of attorney to represent Daniel. Now, question number one. Is the principal in this case, Daniel, bound by the contract entered on his behalf by the agent David? Sure. Why? Well, we discussed this in the last podcast. David was an agent who acted with actual authority, and therefore, conclusion, the principal, Daniel, is liable. But in this podcast, we're looking at whether the agent is liable for this personally. Is David, the agent who had authority, is he personally liable? And the answer is no. Why? Because he disclosed his principal and he acted with authority. So Karen, the seller, was never relying on the agent to pay. She always knew who the principal was. She was never thinking that the agent was liable. So we're protecting the reasonable expectations of the parties. She knew who the principal was. She was never relying on the agent. She can hold only the principal liable. Now let's change the facts. Suppose that Daniel, the agent, comes to Karen and says, I have a client who's really interested in the property. I cannot disclose the client. However, I am authorized to act on his behalf. Now let's suppose there is a breach of contract. Is the agent, Daniel, personally liable on this contract? Well, again, use our principles, protect the reasonable expectations of the third party, in this case Karen. Was Karen reasonably relying on the agent? Well, yes, she was, because she didn't even know who the principal was. This is an example of a partially disclosed principal. We know that there was a principal. David told us that, but we don't know who it is. So, under those circumstances, if it's simply a partially disclosed principal, the third party is at least partially relying on the agent for performance. And therefore, conclusion, the agent will also be liable. Change the facts again. Suppose that the agent, David, comes to the seller, Karen, and doesn't mention that he's representing anybody. It looks like he's acting on his own behalf. If he says, I want to buy the property, I'd like to buy the house, here, let's agree and sign off on everything. Later on, there's a dispute, and David says, oh, well, it wasn't me. I was representing Daniel on this whole thing. Is Daniel going to be liable? Well, let's go back to our original rules. He's liable if he had an agent, David, who had authority. So, yes, he did. So the principal is liable, even though Karen never knew there was a principal. But the problem in this podcast is the agent liable? Was Karen relying on David to perform? Yes, she was. She didn't even know there was a principal. So, conclusion, the agent, David, is liable in this hypothetical. So, the key question in an agent's liability is, did they disclose or partially disclose the principal? If the answer is no, they did not fully disclose the identity of the principal, then the agent is personally liable in the contract. I can give you an example of when this happened. Any of you who've been to New York City may have visited the United Nations. The United Nations was built after World War II because of a hope that if there were a world governing agency, there might be more world peace. The Rockefeller family, who were very wealthy, wanted to donate some land for the United Nations to build a large facility. There was no big plot of land in Manhattan at the time. It was already highly developed. So the Rockefellers sought to buy a whole bunch of adjacent pieces of property so they could hopefully accumulate enough to build this large facility. Well, let's translate to today's terms. If Bill Gates comes to you and says, "I need your house, and only your house will do," even an equivalent house on the other part of town won't do because I need for these to be adjacent pieces of property. And it's really important to me personally, Bill Gates. What happens to your price when Bill Gates wants your house and only your house will work? Well, that's what happened back in the 40s in New York with the Rockefellers. The Rockefellers, however, did not get rich by being stupid. So instead, they authorized people to act on their behalf, never disclosing that it was truly the Rockefellers who wanted to buy these properties. And they did that so that they could get the properties at more like market price. If there'd been a breach of contract, would the agents have been personally liable on those contracts? Yes, because the Rockefellers were never disclosed to the third parties. The third parties were relying on the agents. The Rockefellers, of course, would also be liable because they had an agent with authority. Here's a chart that sort of adds up liability from the previous podcast and this one. So if your question is the agent liable and is the principal liable, let's see whether the principal was disclosed. On the first line, if the principal was disclosed and the agent acted with authority, then the principal is liable. The agent is not liable because the third party was not relying on them. The principal is partially disclosed. The principal is liable because, as we discussed in a previous podcast, there was an agent who had authority. In this podcast, however, we learned that the agent is also liable because the third party was relying, at least in part, on the agent. So the third party can go after both the third party and the agent. Would the third party get a double recovery? In other words, recovery from both the principal and the agent for double the damages? No, of course not. But this gives the third party more pockets to try to get the money. So it is always desirable from a plaintiff's point of view to have as many people to sue as you can because you're more likely to get the money. And frankly, for settlement value, parties often pay just to make the case go away. So in effect, you will often get more money when you have more defendants. Now finally, looking down here, suppose there's an undisclosed principal, like the Rockefellers in the previous example. The principal is liable if the agent had authority. The agent is liable because the principal was undisclosed. Let's go to this third column. Let's suppose that the agent did not have authority. Let's assume there was no ratification and there's no estoppel. If that's true, then the principal will not be liable for the contract because you need an agent who had authority. And in this hypothetical, there was no authority, there was no ratification, there was no estoppel. How about the agent? Is the agent liable? Probably not, but it is possible, and I'll give you two theories about how that could happen. I don't believe this is in the textbook. There's a contract theory and a tort theory. The contract theory is breach of implied warranty. A warranty is something that you are guaranteeing to be true. You've probably seen warranties in products you've purchased. They're warranting that the product will work, and if it doesn't, then they will fix it or something. Here, an agent is impliedly warranting that they have authority. If an agent says, "Oh, I represent this person, here's the deal," that impliedly is a warrant that they have authority to do that. So it is possible that the third party could sue the agent and say, "Well, you implied you had a warranty to represent the principal and implied that the principal would be bound." Or it's possible that a tort theory of misrepresentation might work. The third party might be able to say, you really made a false representation on the scope of your authority, and I want to go after you for that reason. Again, though, the third party would have a hard time showing that they were reasonably relying on the agent if there was no apparent authority. But just keep in mind, here are two theories that make it possible, and you can see the same thing would apply in the instance of partially disclosed principles.